This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why if there is no breach of the insurance contract, there can be no tort of bad faith, and why the Ninth Circuit went through a group of claims to find that some claims were proper and some were not. VIPO Design Corporation and its officers, collectively VIPO, appealed the district court's grant of summary judgment on their breach of contract and bad faith claims against American Economy Insurance Company, AEIC. VIPO's claims relate to AEIC's denial of coverage following a fire at a laundromat known as the Central Laundromat, which VIPO was producing and developing. In VIPO Design versus AEIC, the United States Court of Appeal for the Ninth Circuit on November 4, 2024, resolved the issues presented to it serially. First, it started with the business income claim, and the Ninth Circuit reversed the district court's grant of summary judgment in favor of AEIC, which concerns income VIPO contends it would have earned operating the Central Laundromat if the fire had not occurred. AEIC argued that VIPO's claims for lost income was too speculative given that Central Laundromat was still under construction at the time of the fire and VIPO had not secured additional financing to own and operate it. Construing the facts in the light most favorable to VIPO as the non-moving party, the Ninth Circuit concluded that there was sufficient evidence to create a genuine dispute of material fact and that VIPO's claim for lost business income was not unduly speculative. There was evidence that VIPO was contemplating an arrangement under which it would own and operate the Central Laundromat for a period of time before selling it, and that VIPO later engaged in similar arrangements for other laundromats. VIPO, which was experienced in the laundromat industry, also demonstrated that it had a history of securing financing for its laundromat projects and that it intended to refinance the Central Laundromat once a certificate of occupancy was received. Although VIPO had not secured refinancing for the Central Laundromat as of the time of the fire, VIPO's principal owner stated in her declaration and confirmed at her deposition that it was too early to do so in the project's timeline. That VIPO had yet to finance does not render its claim too speculative as a matter of law, and its losses, therefore, are for a jury to decide. Next, there was a claim for extra expense, and the Ninth Circuit affirmed the district court's grant of summary judgment in favor of AEIC for the extra expenses that VIPO allegedly incurred in storing laundry equipment in a warehouse owned by VIPO's sister company following the fire. While the policy only required the expense to be incurred, not paid, there was insufficient evidence to create a triable issue over whether the expense was incurred at all. No payment changed hands between the two entities, and there is no accounting record showing that VIPO was liable for the storage amount. When the same person signed as representative of both entities, it does not create a genuine dispute of material fact. Next, they dealt with lost profits. The Ninth Circuit concluded that the district court properly granted summary judgment on VIPO's claim for lost profits on the prospective sale of the laundromat, even assuming that such a loss would be covered under the policy. The claim fails because the policy limited coverage to losses that occur within 1 year of the incident. VIPO's plan called for it to own and operate the Central Laundromat for at least 1 year after opening, which would place any hypothetical sale more than a year after the pre-opening fire. Next, there was the claim of individual personal property losses, and the Ninth Circuit affirmed summary judgment for AEIC on the claims by the individual plaintiffs for their own personal property that was allegedly lost in the fire. As the district court correctly found, VIPO did not identify which individual property was lost or its worth. The individual plaintiffs' claims were too unsupported to create a triable issue. Finally, the Ninth Circuit dealt with the claim of the tort of bad faith, and it partially reversed the district court's grant of summary judgment in VIPO's bad faith claim to the extent of the single insurance claim it allowed to go forward the business income loss claim. The district court may permit any further motion practice on the bad faith claim as it deems appropriate. However, it affirmed the district court's grant of summary judgment on the bad faith claims insofar as that claim is premised on any of the other breach of contract claims to which AEIC is entitled to judgment as a matter of law. There is never in California and in the Ninth Circuit a claim for breach of the implied duty of good faith and fair dealing if there was no improper denial of coverage under the policy. And in this case, they found proper denials of coverage on every issue except the loss of earnings. In my opinion, the importance of this case is the reiteration of the law that there can never be a viable tort of bad faith claim if there is no improper denial of a claim by breach of the insurance contract. If the one cause of action remaining was breached in bad faith and there was no genuine dispute over the coverage issue, that cause can be brought for bad faith damages. The other decisions of the Ninth Circuit were obvious and well-reasoned, and they can, since they were viable denials, never be part of a bad faith claim. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you subscribe to the blog, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 4,900 blog posts. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, or insurance law, please consider for a very small fee my Substack publications. Thank you for your attention.